Good morning, everybody. Good morning, good afternoon, good evening. Welcome to the Shamba Centre for Food and Climate's webinar on reforming competition law and policy to empower SMEs or MSMEs in developing countries. I'm very happy to welcome a fantastic panel for today, and I'd like to start giving the floor to Karen Smaller, Shamba Centre's Executive Director, to give you a few words. Shamba, Karen, the floor is yours.
Thanks, Myriam, and welcome everyone today to this webinar. For those of you who've joined our webinars before or who've seen us speak before, our mission at the Shamba Centre is to end hunger by disrupting the global food system. And one of the ways we think the system needs to be disrupted is by addressing the concentration and consolidation of unfair power in the market that's preventing small-scale producers and small and medium enterprises from entering, accessing, and benefiting from market opportunities. So we've started a research stream on this work. And what we're finding from our research is that for more than 2 decades, we see this trend towards greater and greater concentration in food and agricultural markets. We see fewer and fewer companies controlling both the input supply side of the market and the output supply. And we see lower income countries more badly affected than we see higher income countries, in large part because the markets are smaller and less developed. And what we are trying to call for now is for this to be reversed through better reform of competition law and policy, better enforcement of existing laws and regulations, and making market information more widely available. But if this is a problem that's been going on for decades, why are we trying to work on it now? And why do we think something could happen now? So many of you may have been following the backlash that we see in mostly Europe and the US against digital platforms like Amazon, Facebook, and Google. And the good news is that what we're seeing now in the US and in Europe is a wave of reforms that are trying to better regulate the power of these big tech firms. But what we're not seeing is a similar wave of reform happening in low and middle income countries. And we don't see that same wave of reform that we're seeing in the US and EU being ridden on. We also see the development community being completely silent on this issue, not working on competition issues, feeling like it's too hard. And so at the Shamba Centre, we believe there's this unique opportunity now to build on the reform momentum that we see happening across Europe and the US, to shine the spotlight on what's happening in lower and middle income countries, where that concentration and that consolidation is happening, who it's affecting most, and to basically support the reforms that are underway and the enforcers, the regulators who are trying to enforce the frameworks that are in place. So I'm absolutely thrilled that with us today, we have the brightest minds on this issue, academics who've been thinking and writing about this for decades, and regulators from competition authorities in Africa who've spent their lives trying to make markets work better for the poor. So with those introductory remarks, I'm going to hand over back to my colleague Myriam, who will be moderating this panel. Thank you. Myriam, back over to you.
Thanks, Karen, and thanks for these words. So we'll start with 2 bright minds, Simon Roberts, Professor of Economics at the University of Johannesburg and founder of CRED, and Thembalethu Buthelezi, who is the principal economist of one of the principal economists of the Competition Commission of South Africa. Simon, Thembalethu, the floor is yours, and their bios will be in more detail shared in the chat box.
Thanks, Myriam. Thanks, Karen. And thanks to the Shamba Centre for leading on this really important area of work. As some may know, we've been working on this for a while at the Centre for Competition Regulation and Economic Development at the University of Johannesburg, and more recently in an African Market Observatory initiative. I'm going to kick off with some introductory comments, looking at the overall picture, and then Thembalethu is going to come in looking at the reform proposals that we're putting forwards. If you can move to the next slide, Thembalethu. So what we're doing is we're reviewing, I think, what many people may know already, which is the extent of market concentration in food systems, so the particular focus on African countries and across the African continent, and thinking about its consequences. This is the basis for understanding whether and where the institutions are at that are responsible for being the referees to these markets, the competition authorities that have been put in place in many African countries. And that's essentially a reality check, which provides the basis for developing the reform agenda. And we're looking forward to the comments of the other experts that are on this call on that agenda. Next slide, Thembalethu. Thanks. So I think there's been a lot of work internationally around how concentrated food systems have become. This work happened before the digital platforms focus, and in some respects, the digital platforms focus has actually taken attention away from the work on concentration agri-food markets. The concentration hasn't gone away and is still as important as ever, and is extremely important, obviously, for countries that rely to a large extent on agriculture. Some kind of high-level statistics. I mean, in some of the big agrochemicals, fertilizers, pesticides, as well as seed inputs, you've got very small numbers of firms, 3, 4, 5 firms, which account for the great majority of supply in key product areas. In commodities trading, also around 5 firms account for the lion's share of activities there. And in processing in areas such as meat, which I'll give an example of, you've got a very, very small number of firms. Now, large firms are important in terms of economies of scale, of course, but it means these firms have got the ability to shape these markets. And that means that they have market power. And market power means that smaller market participants in these sectors are vulnerable. They can face very high input costs, very high prices for fertilizer, for example, and seeds, and they can also face very low prices for their outputs because they're selling into value chains. They're selling their soybeans, for example, into markets where there are very, very large buyers. So we've got a set of a phenomenon which are really working to undermine the participation of small and medium enterprises and smallholder farmers in these value chains. It also means that food prices can be very high in African cities, and this has been found in a number of different studies. Food prices in African cities are actually higher than in cities in other developing regions around the world by up to around 30%. Next slide. So just to give an example to bring this down to earth, around 20, 30 years ago, there was around 30 suppliers of breeding stock of poultry. If you were in poultry, you could source different types of breeds from a range of competing suppliers. Through large numbers of mergers around the world, there are just 2 global suppliers of breeding stock and poultry. These suppliers account for 90% plus of all of the breeding stock in the world. Essentially, they control these markets. They determine who's going to be in poultry production, and poultry is one of the cheapest sources of protein in the world. So it's really important. It's also a source of income generation and value added in countries around the world, in agricultural countries particularly. Now, you may say, well, these two companies may well be competing vigorously with each other. Well, we know that's not true. There's been cartels being uncovered in the USA last year of these 2 plus major poultry producers, the largest meat producer in the world, JBS from Brazil. Was also involved Cargill, the largest grain trader in the world, was also a part of this poultry cartel. But also in Zambia recently, and I think Chilufya Sampa may talk to this about breeding stock being controlled there. So you've got a situation where you've got producers facing high prices on their inputs, but there's also wholesale arrangements where these producers are vertically and horizontally integrated into producing soybeans and maize and animal feed from that, having an impact on farmers of these crops. Next slide. So we can see arrangements such as cartels, most obviously, which increase prices to buyers. And those buyers may be farmers if it's the prices of fertilizer that they're buying as key inputs. And really big overcharges have been identified in a number of these cartels. Cartels have been identified in South Africa and Zambia and a lot of these different products. But also we see an exertion of bargaining power which squeezes the margins of farmers downwards through looking at the prices that farmers get. And what we in the Market Observatory work have found is that prices for farmers have been pushed downwards where soybeans, maize, for example, are being grown, and prices have been pushed upwards to buyers, such as in East Africa for supplies coming from countries like Zambia. So we see massive excess margins being made at this trading level, which are both undermining production and increasing prices. And these are cross-border arrangements, so it's really important that we have regional authorities to address these situations. So we've got very large firms which are often supported by governments in the past, are able to lobby to make legislation more favorable for them. These large firms essentially control the information and data. Digitalization potentially makes this worse rather than better, because it means that the value of this data is even greater. And these mechanisms reinforce the entrenched positions of these firms and enable these firms to engage in a series of strategies to exclude smaller producers, raising those costs of smaller producers who may be competitors, posing various obligations, exclusivity around, for example, the poultry breeding stock, and also engaging in discriminatory conduct. So we've got a really big problem both in the concentration and in the phenomenon and arrangements that come out of this, which are directly relevant for understanding these agricultural value chains. Let me hand over to Thembalethu now to go into more detail in terms of what we're proposing.
Thanks, Simon. I think I'll begin this half of the presentation just by highlighting, let's say, 3 or 4 key points. And the first one is that it's clear that increasing concentration does have significant consequences for food systems in Africa. As demonstrated by Simon, one clear consequence of this concentration is the emergence of anti-competitive behavior by the global or transnational firms. I think the second point that's important to highlight is that it is apparent that small-scale producers and consumers are negatively affected by increasing concentration and anti-competitive behavior that's emerging. And this is either through the high prices that are incurred for staple food items or through the limited entry and expansion of small-scale producers in local markets. So with that in mind, I think the third point then follows a lot easier, because then you can see that at least in terms of the current competition regimes that are in place, they do face a variety of challenges that do limit their ability to directly address these concerns. And these challenges can range from either being unable to obtain information from parties that don't have a physical presence in local markets, being unable to assess the effects of mergers or conduct due to the lack of physical presence of global or transnational firms. And then also the inflexibility of competition laws that are currently implemented that don't allow for authorities to be able to directly address, firstly, the impact of mergers or conduct on small-scale producers. And this lack of inflexibility does lend itself to authorities in a way having their hands tied on how much they can do to address the concerns we have looked at. So with that context in mind, our proposals then fall into trying to address this lack of flexibility that the current competition regimes have. So one way we have looked at this is to propose, firstly, being able to build effective competition regimes that allow for there to be flexibility in addressing the concerns. And this flexibility that we are proposing is in effect tailored solutions that are based on the country context. So what we have done is that we've grouped sub-Saharan African countries according to about 4 groups, which in essence look at the ability, whether the countries have laws that address competition issues and how those laws are framed, the institutions that are in place, and the workings of those institutions, as well as the enforcement experience or the actions that have been taken by these institutions in addressing competition concerns. What we do see is a variety of regimes across the continent, and that variety of regimes means that tailored solutions are needed to address the particular level of development that a competition regime finds itself. And as I'd highlighted earlier, flexible competition regimes is what we want, that are able to keep up with developments in the market and allow for institutions and authorities to be effective referees in markets. So some of the key reforms that we are proposing is firstly to have legal frameworks that allow for institutions to be able to assess the impact of small-scale producers. This sounds like an easy thing, but if you think about the experience that competition regimes have had within Africa, a lot of the legal frameworks do limit competition authorities to only looking at the effect on prices. So a reform that speaks to perhaps caring about inclusive markets opens the door to being able to look at what is the impact on small scale producers in a direct way and not an indirect way, which says that, well, if I address price effects, then it should almost follow on that all the other effects will be directly addressed. So it's that kind of reforms which we are proposing, the objectives to competition laws to be able to allow for inclusive and broader consideration of markets. Similarly, if we look at the legal framework, the strengthening of regional authorities to be able as well to protect small-scale producers is important. So pushing the boundaries to just a price effect, but being able to recognize that inclusive markets, small-scale producers being part of those markets is something that's important for these regimes. Other reforms that we speak to is on strengthening the powers of competition authorities to allow for them to be effective referees. So being able to obtain information from third parties with physical presence or not, but parties where if the conduct of the party does have an effect in national markets, it should follow that a competition authority is able to obtain information. We do know that there are some international arrangements that do try to assist in this, but to date, some of those information sharing protocols have faced significant challenges for African authorities that have relied on. And I can speak to the actual experience of some authorities in light of this. We also are proposing for tightening of merger control, cartel, and abusive dominance conduct to allow for authorities to be able to address international mergers and cartel arrangements. This is not a hypothetical type of situation, and the experience that has been seen, particularly in relation to cartel arrangements, has meant that African authorities have struggled to be able to tailor in international arrangements, and this is powers that are required. So with this in mind, and with these reforms, it should allow for, and this type of rethinking of competition policy, it should allow for enforcement to start to work for small producers and farmers. Currently, hands are tied in that the reforms or the objectives that are required for small producers and farmers are not front in mind in terms of how the competition laws have been drafted. I think our second proposal is for us to go beyond perhaps the national interests, which I've just highlighted, and to advance regional and continental efforts, as well as reforms in terms of the mechanisms that are in place there. It's important to bear in mind that most dominant firms that we are concerned with that are operating in food markets are likely to have a regional or international presence. And many competition issues are replicated across countries or have a cross-border nature because of the functioning of these dominant companies. And we've seen this before in terms of how cartel enforcement, for example, the cement cartel was South African firms, but which were operating across the region, and you know, a regional effort may have been mutually reinforcing in terms of the national efforts that certain institutions did put in place. So I think there's a clear case that regional enforcement of competition is required alongside national authority enforcement and actions. And and specifically, we propose for mechanisms that allow for clear coordination and cooperation between national authorities and regional authorities. And there is a very apt opportunity that's in place, particularly for continental efforts, with the drafting of the African Free Trade Continental Trade Agreement to as well elevate the importance of competition enforcement on a broader scale. And there's a lot of work that's been undertaken here. Our third proposal is in relation to the use of a market observatory tool. And this tool will allow, in essence, will work hand in hand with national and regional authorities to collect data on markets. Again, yeah, a point which should be obvious, but is not. Without data, it would be impossible to identify where anti-competitive behavior is occurring. So the work that a market observatory tool will be to address that gap that's currently in the market. Firstly, by monitoring key markets and value chains and providing the data that's required. And secondly, to conduct research that can inform inquiries, conduct, as well as advocacy campaigns that are based on regional efforts. And this, again, is not a hypothetical. There is currently a well-established African market observatory, which is conducting price tracking of key food markets. And I've just highlighted below some of the markets that are being currently observed and the work that's been done across a variety of countries. And what the African Market Observatory is finding and is showing quite well is that you do lose very key insights by only focusing on national trends. So for example, if we look at mergers at a national level, if you only focus on a national level, you can miss the regional consolidation, which may be taking place, as well as which may be informing possible coordinated effects at a regional level. And you would okay a merger on a national basis, given the market structure that you're seeing nationally, but it has these unintended consequences that which would not be first in mind if you don't also look at regional consolidation. And so it's very important that a regional view takes place for these African markets. So what we think is that with this improved kind of competition enforcement and improved regimes that are flexible and are able to address directly the impact that small-scale producers are facing in terms of the global concentration in agri-food markets, that they can be some impact, an immediate impact, which can be seen. So for example, if we look at merger control, there should be a way, we should ensure that global transactions in agri-food markets are reviewed by competition authorities because they have an impact within the local markets, despite some of these firms not having physical presence in those markets. Similarly, for abuse of dominance and cartel cases, authorities must have the ability to initiate and conduct investigations that are based on these international arrangements, given that the impact is also felt on a national basis. And we also think that there is a very clear way that there can be impact arising from the use of market inquiries and studies, which can provide cross-country research into strategic agri-food markets. So the empowerment of competition regimes to be able to provide direct impact on small-scale producers and allow for them to demonstrate effects of purely working markets and outcomes from competition interventions is important. So in conclusion, these are the main points that we wanted to highlight, and the insights that we are highlighting is that African food systems are held back by anti-competitive behavior. Small-scale producers and consumers are negatively affected by these behaviors. And there can be three key steps which we believe will make a difference. First is the tailoring of regulatory and institutional solutions, which can allow for solutions to be made that address the direct stage of development that each country is at. But parallel to the recommendations we're making at a national level would be that a regional approach is key. And this is given the cross-border nature of the anti-competitive behavior that we are concerned about. So a regional enforcement will be a very effective way to achieve results within Africa. And our third point is that data and technical support are required, and that the use of a market observatory tool, firstly, to provide data, to be able to allow for authorities to identify where anti-competitive behavior is happening, but also that the market observatory tool can also provide technical support that can support any regional or even national enforcement actions for authorities that require it. I think that's where I'll stop for now, and I'll come back where needed to provide more detail. Thank you.
Thank you, Thembalethu and Simon. This was a fantastic presentation. And now we're delighted to have 3 other bright minds, as Karen said. And I'm very happy to welcome Professor Eleanor Fox, Professor Emerita, and Walter G. Derenberg, Professor of Trade Regulation, Emerita at New York University School of Law. Thanks, Eleanor, for being here. And I'd like to welcome Dr. Moore Bakhoum, Assistant Professor of Law at Université Numérique Cheikh Hamidou Kane and Affiliated Research Fellow at the Max Planck Institute for Innovation and Competition. And finally, Chilufya Sampa, former Executive Director of the Zambian Competition and Consumer Protection Commission. So we have seen that Simon and Thembalethu have shown us a bit that, well, market power means that smaller participants are vulnerable, that is limiting access to food and probably increasing poverty. And Thembalethu has insisted that these solutions should be tailored and flexible. And I'd like to start with you, Moore. We would like to have your perspective and your reactions, maybe from your expertise, which is really West Africa. Moore, the floor is yours.
Thank you very much, Myriam, for the invitation, and thank also for my co-panelists, Simon and Eleanor. And it's a great pleasure to meet you again and to discuss this issue. If we consider the topic, I think it's really somehow what I could term as competition law on the ground in play, because we're looking at competition law in areas somehow that have a strong and effective impact on the livelihood of people. And I think we think about competition law, and currently with the wave of regulation focusing on tech somehow, as Riley pointed out, we tend to forget somehow that there are real life issues that competition law could deal with. And I think the agricultural sector, the agri-food business actually is one of those issues that actually we should tackle. And before coming back to the context of West Africa, just a reminder that in a framework of a project that we started 10 years ago, actually, the agricultural sector was a key point that we wanted to look at when we wanted somehow in the framework of the project. At the Max Planck Institute, Professor Eleanor Fox was involved, Michal Gal, and also Professor David Gerber. What we wanted to look at is what are the economic characteristics of developing jurisdiction, and somehow makes the link with competition law. And one of the findings of that study is that actually in the framework of developing jurisdiction in general, the agricultural sector play a key role. And actually, the West African context is no exception actually to that main characteristics. And it's actually the backbone of the economy in West Africa. And as you already know, it affects society in many ways. And actually in West Africa, it's the biggest employer. It really has a great impact on the national economies, on people's job, on income, and also on food security. So we're having a look somehow at how the market is structured and how the market works and how competition law could help make the market competitive, and understanding the dynamic of the market is very important. And in the context of West Africa, what is still lacking somehow is actually how the market is structured and the dynamic of competition between the big agribusiness and the small producers. And I think in the framework of this project, one of the things I really love is this idea of having a market observatory that have a look at the sector in general and each staple actually to see actually the dynamic of the market. The study, I guess, is so far has so far focused on the market on Eastern and Southern Africa, and I think it will be interesting to see to explore it in the context of West Africa, and I think the key finding of the study, without any data, because we haven't had the study yet, just observing the market somehow could be seen in the context of West Africa. Now, coming back to what we're trying to do, we observe that somehow there are big concentration of the market that could affect the competitiveness of small and medium-sized enterprises and could have impact on food security. What can competition law do? And how can we tailor competition in order actually to address those issues? And I think I totally agree with all the orientation in terms of reform, having a competition law that is somehow take into account context and is context specific. The regional dimension is really very important. And I think in a number of studies somehow, and I think again, in the framework of this project, one of the first publications that we dealt with was regional integration and competition policy that highlight actually the importance of tackling those issues in the regional perspective. And I totally agree with this approach. But here, when we talk about concentration, we look at, and I think in the proposal for reform, one of the key aspects that will be very important, of course, it's mergers, but also how we approach abuse of dominance. And here I want somehow to highlight one issue that is often somehow overlooked from a legal perspective. And I think that could be considered a key tool when addressing abuse of dominance. Because when we look at dominance, somehow the test is that you have to find first dominance to assess the market and then find abuse in order to apply the law. But in the West African context, and even in France, you have it, in Germany, you have it, there is a specific concept of abuse of economic dependence, which we have in our law, which really, of course, it looks at the asymmetry of power between a dominant buyer or a seller without looking actually whether there is a dominant position in the market in order actually to find that there is an abuse. And I think this concept of abuse of economic dependence in the framework of this project and in the framework of this reform, actually, it could be a key concept that one could explore. I know it's not somehow familiar in the context of the law in Eastern and Southern Africa, but I think it really has value, and it's something that we have to consider. Two elements before I hand over. We've been so far focusing on the institutions, on the law, on reforming the law and enforcing the law. It's very important, but there are two additional dimensions that I think it's also very important to consider. The political aspect is really very, very important. Somehow lobbying in the sense that somehow giving enforcement power to the competition authority, having the political support, it's very important. And also enforcement with implying also consumers, because here also we're talking about practices that affect directly the livelihood of consumer. So, and I think in terms of enforcement, public enforcement will be important, but also private enforcement in terms of somehow seeing how consumer association will be involved in actually triggering enforcement will be very, very, very important. So I'm gonna stop here for the moment and then maybe come back later for additional thoughts. Thank you again.
Thank you, Dr. Bakhoum. This is fantastic. I'm now turning to Professor Eleanor Fox. So Thembalethu and Dr. Bakhoum have insisted on this regional dimension and the fact that there is a cross-border nature of abuse of dominance, but also of mergers and cartels. And we would like to have your views of how does this lay out from a regional perspective and from an international perspective?
So thank you, Myriam, and thank you all. It is a pleasure to be here Myriam, could I start from a more basic place and work up to the regional and international? I think that our colleagues on the panel have made such really important points, some of which I want to underscore before I go on to regional and international. And so we started out hearing from you, Karen, on questions. One, the importance of trying to ride on a wave, which is all over the world, of understanding the power of big firms and trying to cabin the power. I want to say a word about that. And I also want to say, and it's related, a word about the relationship of small scale business to what developed countries think that competition law is trying to do. So starting with the wave in the world of recognizing in a way that's not been done for a very long time, the power of power and trying to control it. I think this is very important, but it hasn't been all wrapped up and implemented. There is a very big argument, even in the United States, pushback on the argument that these very large firms have power that has to be controlled. And the group that is working on uncovering the power is basically called the Neo-Brandeis Group. They're working very hard on this. They are showing how small business is part of the market affected by many big transactions and conduct, and trying to make the case that antitrust should be much more aggressive. In the United States, this is rhetoric so far, with some case law, but very little. It's rhetoric so far, and it's not clear that it was going to have continuing traction. So we have to keep our minds on it and keep working on it. Then the related point about where do small scale business fit into the whole antitrust scheme. And here is where I want to say that what you all and many public policy people are trying to do has a very tough road in overturning presumptions that have been built into the law. And this is trying to overcome what is essentially Chicago school antitrust and its presumptions. And the presumptions that markets generally work well, basically leave them alone. Business doesn't matter. Business doesn't say anything about how markets work. You can have a few big firms and they're competing fine against each other, and don't worry about it. And here is maybe a clincher. If you worry about small business, you are on the wrong track, because you're trying to protect small business from competition, and that's going to make us all worse off. That is a very strong thread, especially in the United States, but of course the United States isn't everybody, and EU has gotten actually more resonance than United States. But that is a very strong presumption that has to be overcome, and leads me to the thought how important it is for research to show the importance of small business to the efficiency of the economy, because efficiency is a word that's been captured by the far right, and it shouldn't be. And data showing it's very important to understand the impact of these big transactions in pushing out and limiting opportunities for entry and opportunities for small business is really key to trying to overturn these presumptions. Because our law has been so oriented, this is competition law, on a model that is saying, look to see the result of this transaction. It might be, and I want to raise in particular, Bayer Monsanto and Holcim Lafarge. Oh boy, my time is up already. Shall I take 2 or 3 minutes, Myriam? So these huge transactions that hurt Africa more than any place else, they were cleared by the developed world. They were analyzed from this point of view of, is the transaction going to lessen output across the world? And the big jurisdictions look at it within their jurisdiction and do some spin-offs and say it's fine for us now. And then Africa's left with a huge problem and very little capability of dealing with it because these mergers should have been enjoined in the first place. So this shows two things. One is the very basic analysis is geared towards looking at markets that work pretty well and then sort of cleared for the world. And so the second thing is that there's no, this leads up to international, there's no really very strong, well, there's no continental enforcement in charge. They could have said, we look at these mergers for Africa. We show you these very particular harms in Africa. And we believe the merger ought to be enjoined and just enjoin it. In big mergers like that, my own view is, interestingly, that if Africa had a person at the table to vetting those big mergers, it would have sort of led the way for a better world analysis, even in the developed countries, and shown them that an injunction against these big transactions would have been much better than the little fixes that they did. So I'm already on my last point. I mean, it is the international one. It is the one Myriam said. And this relates both to regional and to continental Africa. And also the work that you have been doing, Myriam and Simon, you've been doing this great, great work to show the importance of getting at the cross-border cartels, even just surfacing that they exist. So that's the data point, plus there has to be the will to enforce point, and both are absolutely vital. I think getting a competition authority for the Center of Africa can really help all of those issues. Every single issue I mentioned, it can help. It can do the view of the whole continent, the view of where the harms are, because the harms are usually cross-border, and most of the harms are from international companies, where the home country might possibly win more than it loses because of increase in profits. So having a regionals with will and continental with focus and will could be a very good step. Thanks.
Thank you so much, Professor. It's what can I say? Chilufya, you've seen that Professor Fox and also Simon and Thembalethu have insisted on one thing, enforcement, and that's a big chunk for competition authorities. So can we have your views on maybe what are the opportunities, what are the challenges from an enforcement perspective?
Yes, thanks, Myriam, and to the panelists. This is very, very interesting. And I would like to start with a point that Professor Fox had just raised, where you have mergers that happen in and cleared in the developed world, and automatically it is expected that they won't have effect in the developing world. And I'd like to give an example, my experience, especially when we're looking at major review. And there would be South African firms that would merge and they would have an effect on the Zambian market. And one of the things that they would say as they come to notify the Zambian authority is, but this merger has already been approved by South Africa, so why do you need to review it? That just gives you the type of pressure sometimes that competition authorities have to face, especially when people come to the authority, which probably doesn't have adequate capacity, doesn't have adequate resources, and say, well, in Europe, it has been authorized. Why shouldn't it be authorized here? And it won't even have that market effect. But to just look at generally the state of competition authorities in the regions. And I'll look at COMESA, SADC, and ESC. In the ESC, basically, you may only say that Kenya is the only competition authority that is up and running and has cases and is performing quite well. Whereas countries like Uganda, they still have a bill to pass. It's in bill form, it has not been passed yet. So no competition authority there to actually review cases. Rwanda, something similar. They do have an authority, but it's still very much in its nascent stage. Ethiopia, something similar. So you can only speak about the Kenyan authority and the Tanzanian authority. The East African Competition Authority hasn't really taken off. So you can see that the capacity of even the regional body there isn't up to speed. You go to COMESA, again, you have something similar. You have Egypt, you have Zambia, you have Mauritius, and probably Zimbabwe and Malawi, but most of the countries are still very, very small. They do not have adequate resources, they don't have adequate manpower, so they really cannot undertake competition assessments to the level that is anticipated. And the same thing with SADC. Again, you have South Africa, you have Zambia, Mauritius, and you see COMESA has 22 countries, and you're only speaking about a handful of competition authorities. Many other countries don't really, or even if they do have the law, they probably don't have an authority, and so on and so forth. And it's the same thing with SADC. I think almost all the countries have competition laws. However, when you look at the institutional framework and whether they've got that ability to actually carry out investigations and complicated investigations in terms of abuse or cartels, investigations that can take a number of years, that becomes problematic, even for countries like Zambia, which is because they drain a lot of resources, and you do not have those resources to continuously investigate just the one case. So I want to also to agree with Thembalethu when she spoke about the legislation and having that tailored to the circumstances. And that is the only way that even governments will start appreciating what role competition authorities can play in development. Right now, when you look at the pieces of legislation, except the South African one, which actually recognizes the historically disadvantaged people, many of the legislations are very puristic in terms of just looking at markets and prices. It doesn't look at what is actually pertaining and affecting the countries in the economies in their countries. Things like poverty, things like unemployment, things like how do you integrate the small scale enterprises, that you have high prices of food, and now there's the new thing of climate change. All these issues are topical, but however, the competition law seems to be detached from those realities, and that becomes problematic. Now, I would also like to just maybe speak on some of the cases that the Zambian authority did look at in terms of cartel. Simon had mentioned the poultry sector, and this we found that there was an agreement within the poultry sector and effectively affecting the price of day-old chicks. And day-old chicks, basically, you would say that's an input to the poultry sector, or having a bird on your table. They were limiting the production of the day-old chicks, and so they would only have limited amounts of day-old chicks that would be supplied to the market, hence having a higher than competitive price. I think if I recall, South Africa was about 25 cents to a day-old chick, while in Zambia it was as high as 75 cents to a day-old chick. And in fact, more recently it had gone up to about $1 to a day-old chick. So you can see that already just before you even start raising the chick, you have to pay $1 for that particular chicken or for that particular bird. Fish fingerlings, that's another cartel that we found with price fixing. Again, it's an input, because before you harvest your fish, or these are commercial farms, fish farms, again, we found that there was a price fixed on that. In fact, they were about to increase the price when that cartel was busted. We had also a case in bread in a region of Zambia called the Copper Belt. This is where the mining industry is. And they had increased the price of bread by a minimum of 2 kwacha, which, well, now in dollar terms is not much, but then it was. So it affected quite I can say that almost half of the population of Zambia lives on the Copper Belt. And so it affected almost 9 million people by just having that cartel there. The fertilizer cartel, which is also another input into the maize meal, which is our staple food, that tells you that immediately you have an input price that is expensive or anti-competitive. Then the price of the final product, of course, would also be very high. And this had gone on for quite a number of years. And some of the reasons when we did bust the cartel, and we did find that there were government policies that were actually promoting or supporting that particular cartel. And probably because they didn't really understand at the time, they didn't understand the movement of competition or having competition there. So we had price fixing and market allocation in this particular case, and these two companies have been had been basically milking close to $20 million every year from the government because of the program that they have on fertilizer support program. So maybe let me end there.
Yeah, thanks.
You were about to stop.
Examples.
All right, thanks.
Sorry for that. That's great. And I think the fertilizers examples is one huge one to show that advocacy is very important, because sometimes, you know, governments or authorities might not realize what is the extent of the money that is being lost in markets that are not competitive. So I'm just going to go back to Simon and Thembalethu. So Moore has told us about the importance of observing markets and, you know, collecting data. And he's also mentioned the abuse of economic dominance. And Professor Fox has told us about this huge mission that is the overturning of presumptions that might be giving a hard time to authorities and to regional organizations. And Chilufya has given us examples of cases that were successful, but also told us that there was a challenge, which was the limited capacity of authorities. So would you like to react on this? Any of you two, I'm happy.
Thanks. Maybe let me just kick off, and we'll use the same order as before, and I'll reflect briefly. I mean, I think these are really important insights and windows into arrangements that exist. So starting with Chilufya Sampa's point, I mean, these are absolutely critical to agricultural development in Zambia. I mean, talking about fertilizer, you're talking about the breeding stock for the old chicks. I mean, you're talking about a situation where before you even start growing the chicken, you've got this incredible high input cost, high fertilizer prices are undermining agricultural production across the region. And this is in the context of drought that's been happening in the Horn of Africa and East Africa, so even more important for food security. But I think the one thing I want to highlight is from our work, and I think people involved in these cases know this, but maybe just emphasize more widely, is these are not national arrangements. These are not national companies. These are international companies, and these are regional arrangements, if not wider than that. There are export cartels that we know about, for example, in fertilizer. So I think we shouldn't be under any doubt about the fact that these arrangements exist. And then we need to look at, well, how do you strengthen the regimes to tackle these arrangements? We've got a referee at the moment, I think, or referees, some of whom are absent, some of whom have not yet got their equipment, and many of whom do not have anything closely equating to the VAR to actually see what's going on. Right? And then you have to have the power to give red cards. Because if you don't have the power to give red cards, then you just say, well, these things are happening, and the companies say, oh yes, we're very sorry. So what? And in their terms, that means that they go to court and hold this up for very long periods of time. So I think I want to just point to the fact that we should all be. I think there's a consensus that we need to recognize around how important this is and how essential this is for agricultural development, particularly in African countries, and move to like, okay, so what can we do? And maybe we can talk more about that, shifting the onus onto companies where they've been involved in a cartel in another country and they are exporting. There's a presumption, I think, that that cartel will be having an effect. This means embodying this in regulations and laws. We've got a cartel in the US in poultry breeding stock that existed and was uncovered in 2021. These are the largest meat producers, the largest poultry producer, and largest grain trader in the world. The idea there was only a cartel in America is, is not believable. And I think we should be thinking about, so how do we then take this forwards? I can talk more about this, but I think I want to ask Thembalethu to kind of say, well, what are the kind of proposals? Because she skipped over some of those points quite quickly. And I think we can get to saying, well, what can be done about this? Because I think a lot can be done about this. I think one of the risks is that we say this is all, this is all too difficult. I don't think that's the case at all. Actually, I think there's enormous amounts that can be done with some quite practical steps. But let me leave my comments there, and I'll come back in again possibly.
Thanks, Simon. Just to add, and I think a lot of my comments were actually on the presumption point, because I think what you've raised, Eleanor, as well as more, is quite important. And I just wanted to firstly start off by highlighting that it's not that theoretical to think about what a change in presumption means for how you then consider competition law. And I'll give one example from South Africa, where with the introduction of some of the amendments to the competition law that considered and elevated what an impediment test means. So if I can just give a little bit of context, Myriam, previously in the South African Competition Act, when you looked at price discrimination, you would have to show as an authority a substantial lessening of competition that arises from the charging of different prices. But that substantial lessening test actually meant showing that a firm has exited from the market, which is a very high barrier and a very high standard to consider. When you're thinking particularly of small scale producers who are coming in to say that I'm being charged a particularly higher price, it's harming me, but yet that the answer, at least in terms of the case law, was that, well, if that firm is still in the market and the other firms are still also able to compete in that market, then it's not significant enough to say that it has an anti-competitive effect. So by a slight introduction in terms of a provision to say that, well, you can also show an impediment to a certain class of firms, right? And that class of firms, we define it given the South African context. We look at historically disadvantaged firms, but we also do consider an SMME, so a small scale producer. And just by the introduction of an impediment to a firm, that now opens up to that nuance of, well, if it harms that firm's ability to compete, that is enough. Right, and then shifts the onus to a larger firm to show that, well, why should we not consider that to be presumptive on impeding that particular firm? We have sufficient other examples where you consider I call it a natural experiment from the COVID-19 experience, where just by being able to rely on some of these amendments in the law, a greater onus is placed on dominant firms to be able to say, why did you include that kind of conduct, and why do you actually consider that to be efficiency enhancing? Which takes away quite a large burden on national authorities to be able to prove the case of, one, I have to show there's an effect, and that effect must not only be on a firm, it must be an entire market. And then over above that, I also have to weigh up any type of justifications that a dominant firm provides to say that, well, your justifications don't suffice. So a change in onus, and these are the practical type of reforms that we are speaking to when we talk about legislation, is a shifting in onus to place more on dominant firms. I think more, you termed it quite nicely in terms of that economic dependence, because then that does narrow it to a relationship between a smaller firm and a larger firm and what that means. I think that's a very good suggestion to think to and how to bring that in. But a change in evidentiary burden in terms of competition authorities is important, as well as what I'd spoken to in terms of objectives. If we are able to look at broader objectives instead of just price effects, it does also then start to shift the ball game in terms of how much leeway authorities have to be able to address these types of impacts on small scale producers. I think even, you know, my last comment will be, even for mergers, it's not hard to think of a mechanism that means that allows for any acquisition by large firms, even in related businesses. So it might not be in the direct market. So if we use the example of day chicks, it might not be in that market, but if you start thinking about a value chain, you know, where else these producers might be. So if they're providing input to the production, so fertilizers, you know, that you would need for day chicks, etc. If we start to be able to look at acquisitions, even in related businesses or related markets, the firms themselves should be able to come in to say, why is this firm not anti-competitive? And what kind of efficiencies we will realize, as opposed to the onus always being on the authority to come in to say, this is why a certain transaction is anti-competitive. So that shift, I know, Eleanor, you spoke about it being particularly hard, but I think the US does have that difficulty, and there are some examples that show that once that shift is actually on paper, it does allow for competition regimes to have a slight more flexibility. And we see this in the way that I think, as highlighted, South Africa, but I think even Kenya, if we think about what they're doing with their biopower provisions, that slight shift does start to realize real impacts for small scale producers. I'll stop here so we can hear more from the others.
Thanks, Thembalethu. I'll give the floor to Professor Fox, maybe for first reactions and then more. Your mic is muted. Oh,
yeah, got it. Thank you. Okay, so this is really helpful. And I want to distinguish proving a case under the law that exists, for which you might need presumptions that we don't have because the burdens are so high, even to prove the case under existing standards. And then I want to go to, second, should there be changes in standards in view of need to protect, I mean, the poverty issue, the inequality issue, the dependence issue? Should there be a change in standards so that the competition law actually helps the poorer population and prevents the extreme exploitation that we're seeing in this new economy? So on presumptions, I agree, I mean, with everything several of you said, and Thembalethu just said about we actually need presumptions to make the case able to be proved. And that is partly just because the burdens of proof have been so high and the defendants have all the facts. And there's been a lot of work in the world going on right now about changing presumptions, including a lot in the United States, and there's some really good academic articles on it. Of course, it all depends on what the judges will do in the end, and whether the law is there yet, or whether you need a change in law. And the second thing I want to say is going beyond what I'm calling traditional. What I'm calling traditional can be all about virtually everything that you were talking about, Sampa, was actually a traditional restraint. It was price fixing, very traditional. Elevating the price, that's very traditional. Going beyond, there are significant problems and barriers to be met. And that is because if we have competition law that protects all individuals from, say, unfair exploitation, it may go so far that it is no longer protecting the efficiency and the equity and the efficacy of the market to work in the direction of lower prices and more innovation, etc. So there may be limits on the fairness, even for the poorer population. And this is what I suggest, and I have suggested it before. I think given our competition law in the world, various competition laws, and the fact that they are basically so conservative, leaning on the side of it ends up protecting dominant firms. There's a lot of space to work with, which is both fairness, equity, preventing extreme exploitations that fit with a making markets work better model. And I think it's very important to link in your thoughts of protecting individuals with a narrative as well as information about how the scheme you're trying to protect actually will make your markets work better, actually that you're not even going to get efficient markets in your country without such breach of the law. Thanks.
Thanks, Eleanor. Moore, would you like to say a few words?
Yeah, thank you very much for giving me the floor and for the wonderful comments. I totally agree with this idea of somehow going beyond what could be termed as a traditional approach of competition law and really try to see how to balance fairness, inclusiveness somehow without undermining efficiency. I know this has been like a very theoretical debate, but I think in practice also competition authorities should be more innovative in terms somehow on how to take into account those dynamics. But I want to come back to 2 points in my comment. First, the regional aspect. The regional aspect, the transaction has a regional dimension. And the regional dimension has been highlighted as really a kind of powerful institutional tool in order actually to deal with transnational mergers of transnational cartels. But there are also limits to regional integration, and this comes from fact. I mean, in the context of West Africa, somehow we have seen that the West African Economic and Monetary Union, in terms of design and also the distribution of competencies, it has so far not being actually capable actually to have a strong impact actually on international mergers and international cartels. So of course, from a theoretical point of view, it's important to think regional, but at the same time also, we have to give to the regional authorities the political, the institutional, and the material means to do their job. It's a very, very, very important. ECOWAS is in the process of starting enforcement, and I think we have already highlighted somehow, try to put this kind of issues on the structure of the agricultural market in their agenda for enforcement will be very important. My second comment somehow brings us back to the first idea related to platform. And here I want to draw your attention to the close link between technology and agriculture. We're talking about seed, we're talking about fertilizer, we're talking about machinery, but I think in the future, the issue will be more about somehow access to data and how the small and medium-sized enterprises that would transform their agricultural practices, making it more technological oriented, and the need to access and share data, and how actually access and sharing data will be facilitated somehow. And I think in the short or long run, this will be actually a huge problem, because agriculture is becoming more and more digitalized. And I think access to technology and access to data, and from a competition law perspective, will be very crucial. And I think we have to start thinking about the issue now, because I think in the future, it's going to be how small and medium-sized industries, medium-sized enterprises active in the food sector, how could they access data in order actually to improve their producing practices. And I think that is a very, very important point somehow one has to take into account in the discussion. Thanks a lot again, Myriam.
Thanks, Moore. We're now going to open the floor for questions. So we have a few already. So the first question is from Fares Gameldain, who says, thanks for the presentation. Is the end goal to eventually upscale the MSMEs in the agri-food system, or to better regulate conduct of dominant players in the market to allow for participation of the MSMEs? I guess this one would be more for maybe Simon and Thembalethu, but I'm happy for others to react too.
Sure. Why don't you start, Thembalethu, so we reverse the order?
Okay, that's only fair. Sorry, I just want to start off. Thanks for that question. It's a good question. I think we can think about it this way. I think the end goal is both. But I think the focus for today, because there's obviously a very clear acceptance that a multi-based and a broad-based policy strategy is what's needed to be able to successfully tackle the concerns that we've raised. I think the first part in what we at least are highlighting today is a very clear way to elevate how competition law is a powerful tool to be able to regulate these markets, and that it is a tool that with some of these reforms and proposals that we've spoken to can provide a way to elevate the impact that SMMEs have for markets and the efficiency that they also bring through to markets. But that's not to say it's the only tool. There are other tools, but I think competition law is a tool that is sometimes forgotten quite a bit in the debate. And this might be more a reflection of the development of competition law in developing countries and some of the challenges that have been faced. But I think once the regimes are able to function more efficiently, it can be a very powerful tool which can bring real results to the experience of SMMEs. I think, Simon, if you'd like to add, you can come back and.
Sure, I agree with everything that Thembalethu said, not surprisingly, I guess, but it is both. But also just to add two other points, which is that first of all, we need to think about what markets are for. I mean, the markets, I think, are really meant to be rewarding effort, innovation, and creativity. So it's not as if you must support all businesses just because they fall into a category, but it is about the ability for people to participate in the economy and to be rewarded fairly for this, and to deal with unfair conduct. So therefore, conduct which is essentially undermining people's ability to do that. What this means, I think, though, is that competition authorities can be more like markets authorities. They have the powers to find things out. And we've seen this in the digital platforms cases where authorities have actually found out information about how markets work through their powers, which was not known otherwise. This is really important in agricultural markets because it also provides the basis for other types of support measures. For example, governments should be investing in storage facilities and logistics. So if we find out exactly how big the problems are around the access to storage facilities for small farmers to be able to not be forced to sell their crops immediately after harvest, but to decide to wait and hold on and spread their sales, then this is going to make a really big difference to how people can participate in the economy. But we need to know who controls the storage facilities, and we need to know how important these are. And this is what competition and markets authorities can find out. I mean, perhaps you might be surprised to know that, but there have been cases around silos for grain storage in economies as different as Canada and Russia and South Africa. So, economies, very different traditions, but storage facilities are really, really important. They're really important for farmers. They're also really important for food markets. And so I think the other thing is to say that competition authorities as markets authorities doing inquiries can provide a resource in terms of a knowledge base and information, which can make other or help other policies be implemented, which will shape the markets in much more positive ways as well. So it's only one part of the puzzle, but it's really critical because it's got authorities have got this ability to observe and to understand and to analyze how markets are working and the power structures that exist within those markets.
Would anyone else like to jump in? We can also move to other questions. So I'll move to other questions. So we have one question from Rory McMillan. Would you like to, Rory, maybe ask your questions? I see you.
Sure. Oh, I'm showing. Good. I was interested, more mentioned the question of regional integration and barriers to that. And I was interested in, especially in food markets and in Africa, how we might think about how trade barriers amongst countries regionally, continentally, relate to competition issues and how, whether there's a reinforcement of trade barriers, reinforcing competition issues. If you're fragmenting markets by having trade markets, does that make markets smaller, more vulnerable to cartel control, dominance in those markets? And how can one coordinate these two policy areas to really maximize change?
Thanks, Rory. It's really a very, very wonderful, very interesting question. And this is actually somehow, I think, at the heart of the issue about on the link between trade and competition. And I think usually when we talk about regional economic integration from a competition law perspective, of course, the competition dimension is important. But one point is a number of somehow anti-competitive practices at the regional level also have a trade dimension. So meaning somehow you have to deal it not only from a competition law perspective, but from a trade law perspective. And I think in the context of regional integration group, somehow one has to distinguish between two aspects. There is a trade dimension with a number of objective and also of rules on mobility, on trade, on implementation of companies, that the four freedoms are received in the context of the EU. You have it in West Africa, you have it in WIMU, you have it in ECOWAS. But in practice, actually, although you have somehow those trade facilitating rules in the books, in practice, actually, we notice that, and this is really linked to the structure of the market, that only big companies have the possibility actually to do business across countries, because they only have the economic capacity. And also this also relates to the historical, and also SMEs, they don't have this possibility. Their reach is only local. And also this is somehow linked to historical perspective and how actually the market were designed. And I think in this point, one really has to not only think about enforcing competition law, but also enforcement of competition law should go hand in hand actually with limiting actually trade, with removing trade barriers. And I think is also that the job of trade official. And in the context of West Africa, we have so far a number, in the context of WIMU, the enforcement in the framework of WIMU has been so far actually to enhance regional integration, to remove trade barrier. And in a number of cases, actually, it was competition law cases, but more linked to actually to trade restriction at the regional level. And I totally agree. One has really to look at the competition law dimension, but the competition law dimension is strongly linked with the trade dimension. And I think also thinking about it at the continental level, somehow one also has to think about that two dimensions.
Thank you more. Eleanor.
Yes, so thank you, Rory, and also thanks Moore, because I agree, of course, with all that Moore has said, and we did write about this in our book. I think that understanding and tearing down the trade barriers that are procured by the vested interest is an absolutely necessary part of the problem, necessary to the solution of the problem, I should say. And Simon, in your recent paper, which has been in Oxford, you have some indications, some data about how the trade flows that are so suspicious between Malawi, Kenya, a couple of other countries, indicate there are some barriers that are below the radar screen that are keeping the food from passing across borders in a way that you would expect it to pass, and therefore causing much higher prices of food. I think this is an area that has to have much more information. I think also as we get to the regionals, and even if we get, as we get to the continental authority, it is so important for the competition commission to be dealing with the Trade and Internal Market Commission and trying to pinpoint what is happening in the market that keeps the flow of goods and services, and here mostly agricultural products, from flowing in the directions that they should be flowing. And it's probably vested interests procuring various countries' restraints. And then the next step is it against the law, and how to tear it down, which is also a big issue, because some of these sovereign restraints are not against even the trade law or the competition law. And I think there has to be more thinking about getting a better law to catch the cross-border hybrid restraints. Thanks.
Thanks, Eleanor. We're moving on to another topic, which is interest rates. So we have a question from Oshani who's asking how higher interest rates are leading to super concentration in banking, and how will this reduce access to capital, and how does this have an impact on market concentration? And we also have a question from Chris, who asks, where is the African Union on competition law, especially referring to agriculture and food? And is WTO taking this issue up in any way? Now led by an African DG, which is DG Ngozi Okonjo-Iweala. And finally, we have another question from Razia, who asks, we have heard that only a few countries have fair competition laws and even fewer competition authorities, and they have limited capacity and limited funding. So how can Africa solve the unfair competition issue, exploitation, and cartels? Anyone who wants to take the floor is welcome to.
I can take the last one.
Go ahead.
Yes, how can we have competition authorities funded, and how can they deal with cartels and mergers and so on? I think the issue is a matter of understanding what competition does. And I think this is where most governments may not realize the importance of competition law. One of the challenges that we find in many African countries is that while competition law is quite modern, I think the earliest may have been in the early 90s. So we are just talking about 30 years now of competition law. We still have a number of old laws that are still operating within within countries that date way back before that. And for certain countries, you would find that they didn't follow a market economy, they followed a command economy. So there's still this backlog, so to speak, of ensuring that the laws haven't caught up to the modern day, and then it is easier for governments to believe that they can still control markets and not have markets that are free, that can dictate the prices of goods and services. So or at least my position would be, you need to advocate. You need to have research that is based on evidence to show that this is what competition can do. And once you have the advocacy on your side, it is then a matter of showing the policymakers, the decision makers in each and every country that this is what competition law can do. And then you'd have the authorities funded, because you can see that there is a direct relationship between the competition law or the policy with poverty reduction. And I think this is the whole discussion that we've had today, the issues that Thembalethu and Simon were raising, to say changing even the approach, the presumptions that the old competition or the current competition laws may have, changing that will help in coming up with a more easy cause and effect kind of relationship. Thanks.
Thank you, Chilufya. Anyone else want to jump in, either on this question or the others?
Maybe on a few comment on the role of the African Union and also the WTO in general. And I think on the regional level, somehow a lot has been done, a lot is going on, but it's so far somehow concentrated to regional blocks, Eastern and Southern Africa, with COMESA, West African, and so on and so forth. And I think in the framework of the African Union, it's only with somehow the into force of the AFCDA that we have seeing that at the continental level, somehow steps have been taken in order actually to have regulation of competition or an institutional framework that deal with competition law. I mean, the objective is wonderful somehow to have a sort of regulation at the continental level. It's still a process which is going on. There is a protocol which is so far adopted and has to be ratified by member states. But there have been somehow doubt on really the way it is approached and the way competition law is approached, and especially how far should we go in terms of regulation at the continental level. And I think it's an issue that is hotly debated now. And I think there is a close link between somehow how you design the rules at the continental level and actually how effective enforcement will be. And of course, it will be very important at the continental level to have a mechanism somehow to regulate mergers, to share information somehow, to have a common continental approach toward big mergers. But at the same time, it's really very doubtful whether actually at the continental level, somehow one has to have a fully fledged competition authority with full power to deal with cartels, abuse of dominance, and so on and so forth. And not speaking actually about the issue of coherence between pre-existing national law and regional law. And I think this also leads to the second aspect of the comment, the difficulties that we have faced at the global level to have a kind of competition law in the framework of the WTO. Showcase that somehow one really has to be careful. I mean, there have been initiatives since 1995, but Eleanor know a lot, and also my co-panelists, that the difficulty is to come up with a continental, global competition level. And I think so far it's only convergence, and also from an African perspective, there have been a lot of coordination and also capacity building that have been done, especially by the team of UNCTAD, in order to strengthen actually the enforcement capacities of the national competition authority. But I think what will be helpful somehow in that sense also is in terms of enforcement, how to push the agenda in the sense that somehow developed countries would cooperate more with somehow developing country or sub-Saharan African competition authority in terms of sharing information. It's also a very, very important aspect. So I'm gonna stop there for this question.
Thanks, Moore. I see, Simon, you had your hand up. Would you like to jump in?
Sure. Let me come in there and also kind of make a few comments on the earlier question as well. I think first thing as I wanted to say was that while few countries have got, actually not few countries, most countries have got competition laws, but few countries have got well-established authorities. If we have regional authorities that are effective, the countries will not need their own authorities to the same extent. The Netherlands, for example, in Europe, didn't have a competition authority for a very long time because there was EU competition law. And so, this is I think means that the challenges can be more tractable if we think about the nature of the markets that we're talking about. This is not a continental authority. This is about effective regional bodies covering natural markets, which is from areas of agricultural production to cities. It's from ports to areas of consumption. And the colonial legacy means that these are often across borders. Right? So these are often across borders, and we need this regional picture. But there's quite a well-traveled road in terms of analyzing and understanding these things that we can follow. I think we just need to build the political will and the information base to be able to do that. The second thing I wanted to comment on was just on the climate change links, which makes this even more imperative. So climate change is in terms of extreme weather, means you've got these supply shocks that are relatively localized, but the Horn of Africa has had the worst drought in 30 or 40 years. But in actual fact, at the same time, southwest of Tanzania and Zambia had very, very good rains, and in fact has incredibly good water resources. I mean, African countries, some parts of Africa have got some of the best agricultural land and water resources available in the world to expand agriculture. So within the same region, you have the impact of extreme weather, and you have the potential to meet that demand across borders. So I think this is a real push to actually unlock kind of effective markets and with wider participation and greater resilience in the region. So I think that's kind of something that we need to really take on board. And then we've got the roadmap. I think that sets out what we think needs to be done about this. The question on interest rates is quickly to come in on. I think one thing about high interest rates, of course, is that working capital is really, really important. And so access to finance is really a big part of the puzzle, a big part of the picture, because it reinforces the kind of the power of larger traders, for example, who've got access to this working capital. And so we do need to address these things together. So I do think this is a very, very important point to come back to. Thanks very much. Thanks very much for hosting the webinar overall, Myriam and Karen.
Anyone else want to jump in for this question? I see we have a last question from Malik Dasu, who is inquiring about some of the low-hanging fruits that need to be supported to track and crack down on anti-competitive behaviors. Are there organizations and programs addressing this directly that need further support? Ooh, silence in the room. Anyone wants to jump in?
Maybe I can jump in and start wrapping up. We're at time, right? So maybe I will try and address Musa's question, but trying to wrap up. I mean, this has been a fascinating exchange. Thank you so much to all of you who've come and spoken, and all of the people who've given questions. I'm not going to try and summarize so much everything that's been said, but what I want to focus on is all the things about what can be done. So Musa, hopefully this answers your low-hanging fruit question, because I think whilst there's been a lot of critique on the problems, I think there's been even more discussion about what can be done. And I think they fall under these three groups, right? There's one about the law reform, the better laws, the updating of laws, the modernizing of laws, going beyond prices, looking at market inclusivity, looking at broader objectives than just price effects, shifting the burden of proof away from the authorities to those who are having a dominant position in the market. Stronger principles of fairness and equity to make markets work, but I think importantly, as more you said, without undermining efficiency. So that's the sort of first bucket of maybe not the lowest hanging fruit, because law reform is often the longest thing to take place. But the second bucket we've got is all about enforcing and strengthening the existing legal frameworks, the existing institutions. So tackling the issue of cartels, abuse of dominant positions, mergers. We've had a lot of examples about how, a lot of these issues are happening cross-border. Let's strengthen that ability to enforce cross-border, not just only in one country. On abuse of dominant position, let's again shift the onus onto the company that is dominant to prove that they're not. And let's look, as Moore said, about this concept of economic dominance as a key concept to explore. And let's find a way where mergers can be challenged or reviewed, even if they happen outside your national borders. So the call about getting an African competition authority, I think, was echoed by a lot of people. And Simon's last point about let's not be so obsessed with national authorities doing all these reviews, but let's try and strengthen regional authorities. Because if you have good regional authorities, and given how cross-border the nature of these problems are, you may not even need to set up your own national authority. And then support saying, actually, there is a lot happening at the sub-regional level in Africa, so ECOWAS, SADC, COMESA, but very little happening at the continental level. So maybe that is, an area where more can be done. And then I think the third big bucket, where there's clearly been a lot of support from all our speakers, is this need for more market information to support enforcement. And this we've been seeing a lot in the call for supporting the role of the African Markets Observatory to be able to cover more countries, more commodities, and give those competition authorities the information they need to be able to discipline, inform, check on the anti-competitive conduct in the market. But I think on market information, it was more, we went beyond just the idea of having to have market information for competition authorities to helping small scale producers and SMEs better access data. So we had a lot of discussion about technology, access to technology, the increasing digitization of the agricultural sector, and that ability to crowd in and share data and information between small scale producers and SMEs is going to be crucial going forward. I would just like to end. There was this big question about, do we upscale MSMEs and small scale producers? Is that our main focus, or is our focus on regulating and breaking down these big companies? And I think Simon made for me, a really important point that brought together a lot of the thoughts that people have been sharing, which is, this is not about favoring one group over another. This is about having markets that reward effort, innovation, and efficiency. And when we have markets that do that, we have good, competitive, fair markets. And the problems that we're trying to address through stronger competition law and policy is trying to break down where we're seeing markets not rewarding the effort, the innovation, and the efficiency. So at 7 minutes over time, I think I will close. Thank you so much to all of you for being here. Thank you to my colleague Myriam for putting this all together, and for Marley for helping her. And the report will be coming out in hopefully the coming weeks or months. But please look out for it. We will be sharing it and hopefully having more discussions on this really important issue. Thank you, everyone. And I think I'm closing, Myriam. All right. Thanks, everybody, and have a good rest of your day.